That explanation, I'll go ahead and call the first case on the docket. It is from here in Johnson County. It's number 128-510, Sierra Club and Boat Solar versus KCC and Effigy. So we'll start off with, who do we have here for the appellant?
Your Honor, for the appellant, Will Wolford will be arguing the case. Trevor Wolford is with me at council table, and Evergy's in-house counsel, Kathy Dingus, is in the gallery. I'd like to reserve 5 minutes for rebuttal, if that pleases the court.
That will be granted. And who do we have here for the appellee?
Good morning, David Bender for the appellees and cross appellants, Sierra Club and Vote Solar.
Okay. All right. Mr. Wolford, whenever you're ready.
Yes, may it please the court. Panel, this is an appeal of the district court's decision overturning the KCC's approval of a settlement order regarding tariff revisions to address consequences and impacts of wholesale demand response activities on Evergy's state-regulated electric distribution system. So the approval of the tariff at the KCC level is a quasi-legislative function. It is a rulemaking, which is entitled to the utmost deference from the judicial branch, the facts found in that docket. This is a case that concerns wholesale demand response aggregation and rules related to it, which sits somewhat at the intersection of federal and state jurisdiction. But it encompasses principles of cooperative federalism, where states have their own sphere of regulation and the federal government has its own sphere. Evergy's position is that the district court's holding and the appellee's arguments really urge a version of preemption and federalism that would have the federal government essentially muscle out the state's valid and important regulation of impacts from DR aggregation and those impacts on the local distribution grid. This is a case where there was facts presented to the KCC through testimony where Sierra Club, Vote Solar had the opportunity to ask for an evidentiary hearing and did not do that. This is a case with a settlement with near unanimous approval across a broad range of participants, including Voltus, who is the only DR aggregator operating in Kansas. We believe the overturning of the KCC's approval of the order was an error for at least 3 reasons, which I will get into now. First, Your Honors, the issue of standing is a threshold issue that has to be addressed to make sure that there is subject matter jurisdiction and a justiciable claim. For an association like the appellees to have standing, there needs to be members that have a cognizable injury with a causal connection between that injury and the KCC order. It has to be an injury in fact and personally suffered, imminent, and not speculative. What has been presented by the appellees in this case are declarations to attempt to show standing that fall well short of that mark, Your Honors. The injuries that are proposed are both speculative and or generalized grievances, and they do not rise to the level to provide standing to the organization to challenge the KCC's order in court. Those injuries that are proposed in the declarations, why they are speculative, why they are generalized, is this. They are provided on behalf of residential customers of Evergy, generally. Those residential customers, Voltus is the only DR aggregator operating in Kansas. It does not operate a residential DR aggregator service. It does not have a program to provide DR aggregation for residential customers. There is no evidence to show that there is an imminent time when that would arise.
Let me
yes.
Question about
yes.
In your, actually, this is your reply brief. you're making this point. And on page 13, you say, currently there is no ARC that aggregates residential customer loads in Kansas, nor is one imminently expected to start operating in the state.
Yes, Your Honor.
I kind of consider that a fact statement, even though it's not in the facts section. But my question is, do you have a record site that tells us that? What can we turn to in the record that establishes?
Yeah, I don't know. There is some record citation that identifies what Voltus does as a DR aggregator now. I know that is at record 3, 124 and record 4, 168, and it identifies that Voltus only does commercial and industrial customers and only provides DR aggregation for those customers now. I think the record is devoid of any suggestion that Voltus or any aggregator is on the precipice of providing that service for retail customers in the state. Yes.
Let me ask you this question.
Mm-hmm.
I've got a couple of forms here.
Uh-huh.
Maybe I'm not even sure what these forms are, but I think this form here is for residential customers to participate in demand response through an ARC. And this form here is for residential customers to participate in demand response directly without an ARC. Why do we even have these forms if residential customers are never going to be able to participate in demand response, and so they have no standing? Why do we even have these forms?
I think the forms are created in the case that does happen in the future. There is no evidence in the record, and there is no instance showing that an ARC, a DR aggregator, actually is functioning toward providing DR aggregator services for residential customers. However, I think Evergy is preparing for that eventuality at some point. And there is also a difference too between DR aggregation in the wholesale market and the retail market. And so there may be some forms that allow residential DR aggregation in the retail market, but not the wholesale market. But that being said, I think Evergy's approach is we prepare for that eventuality if it occurs, but it is still an eventuality that is not on the precipice based upon what we've seen and what's in the record here in this case, that there is no provider to provide wholesale DR aggregation for retail customers, at least in the near future. The issue also goes to, I wanted to mention in addition, the issue of increased power costs that was raised as a possible harm is both counterfactual and is a generalized grievance. It's counterfactual because the KCC found, based upon the evidence, that it would not, there would not, that the changes to the tariffs would not increase power costs. If anything, it would place downward pressure on those costs, and those findings of fact have to be respected here. And it's a generalized grievance because it's essentially, if it increases costs across the board, it's not a specific injury to that specific retail customer. It affects everyone the same way. So our position is that there is no standing on behalf of the organization. We also, the second issue and error that Evergy cites is that the district court went well beyond the scope of the appropriate scope of review. It went into issues that were not stipulated by the parties. It made findings sua sponte that the KCC had abdicated its role to regulate these activities, which is not true. It's not supported within the docket or within the evidence at all. And Your Honor, I think our brief handles those pretty well, so I'm going to move on pretty quickly. But the point I'd like to make too is I think Applebee's really didn't support the district court's rationale or holding on this idea that the KCC had abdicated its role to regulate here. I don't think there's much more that needs to be said. I think the district court went well outside the bounds of its really appropriate review when it made those findings. The final issue that I'd like to address relates to federal preemption and federalism, which I think is really the meat of the argument here. And
launch into that. Let me
yes,
ask a question. It seemed like the district court was very concerned about Evergy having the right to disqualify or give consent to or withdraw consent to participants in the aggregate market. Are there discernible and definable standards by which Evergy exercises that consent authority?
yes, I believe and I don't have the record site, but I believe that the KCC stated that it is basically a ministerial process of going over to make sure that all the boxes are checked, and if they are, that it gets approved as a matter of fact. The standard, I believe, is that it will not, that approval or moving through the process will not be unreasonably withheld, but it was characterized as essentially a ministerial task for approval.
The forms are submitted and the boxes are checked, then they're in.
They're in. Yeah, it's not a question of, well, do we like this? Do we like this group? Do we not like this group? No. If they check the boxes, go through the process and fill out the forms, they're able to participate.
They have to participate through an approved
An
RA.
approved ARC, correct? Yes, and that's part of the process, and part of the tariff revisions relate to that specifically.
What is the purpose in having these forms? I mean, that's the new part of this. How does that enhance sort of the efficiency and the safety that Evergy is claiming?
Yeah, that is the technicality of that is really sort of above my understanding and pay grade, but there is evidence.
We're not understanding it and asking the question.
Yeah, the evidence that was submitted was that these forms and this information allows Evergy a look into that part of the market and some controls to be able to understand and make sure that demand responses bid in are accurate and the registrations are accurate. It allows them to prepare for fluctuations related to large demand response activity on the grid, which may change not only where power needs to go, but excuse me, power quality issues as well. Not being an engineer, I don't know the specifics of why that is, but that's the evidence, and it is unchallenged, Your Honor. It's not only unchallenged in that Evergy submitted that evidence, that KCC in its findings found that those are valid reasons to have these tariff provisions and have this look into the wholesale DR aggregation activity.
When
So
when Evergy submitted this tariff, there were a number of interveners, including Curb,
yes,
and they later had settlement negotiations, and then you had this partial settlement.
yes.
I'm curious, what were the provisions that Evergy changed that apparently encouraged Curb and other interveners to not only give up their objections, but they actually filed.
Yeah,
in favor.
I wish I had a good answer for that, Your Honor. I don't specifically know what that is. I can see if maybe I can find that answer and update you on rebuttal. But I don't know specifically what those are. At any rate, very quickly, the first off, the threshold issue of that relates to the federal preemption, there has to be a federal anchor. Federal jurisdiction really is over the ARC's transactions with the RTOs and what is being regulated by Evergy and the KCC here is the customer's relationship with Evergy. That's a common area for regulation by state regulators. It does not create a conflict with any federal law. It does not create a barrier to the enforcement of any federal law. It was found not to create a barrier to any participation in DR aggregation in the future. It actually really does complement, I think, federal efforts in the DR aggregation area. And it is consistent with the precepts and principles of cooperative federalism that underlie this program that straddles the line, Your Honor. There are a lot of items to go through in the federalism and preemption issues. I see my time has run out. I think we handled them very well in our briefs. If there are any questions you have for me right now, I'd be happy to answer them. I do note too that there was an issue of ultra-virus cross appeal issue raised by the appellees, stating that the KCC regulated outside of its legal authority. And again, I think we handled that well on the briefs. This is well within traditional regulation authority of the KCC. It is consistent with the KCC's regulation of impacts on the retail grid from various types of programs, and it's consistent with traditional tariff regulation and findings in the court. I'd be happy to answer any questions. Otherwise, I'd reserve the rest of my time for rebuttal.
This might be an overgeneralization, but would you say that Judge Vano found that he found that there was no field preemption,
I agree.
but he struck the tariff down based upon some form of conflict preemption? That's at least a correct statement.
I would agree. He did not find field preemption applied. He found, which we agree, field preemption does not apply. He found that there was some kind of obstacle preemption, which we vehemently disagree with. We think this is complementary to federal power, as we've set forth well in our briefs.
Thank you.
Yes. Any other questions? I'd be happy to answer.
Apparently.
Thank you, Your Honors. I'll reserve the rest of my time. Thank you.
Morning. May it please the court, David Bender for the appellees, cross appellants, Sierra Club and Vote Solar. I'd like to address three topics with the court this morning. First, Sierra Club and Vote Solar have standing. Their members are interested and would participate in demand response aggregation in wholesale markets, but for the burdens imposed by the tariffs challenged here. Second, the district court correctly found the tariffs were preempted by the Federal Power Act. My read of the district court's decision may be a little different than my friend from Evergy. I see findings of both field and conflict preemption in the decision. It goes back and forth. It cites field preemption cases and makes findings consistent with field preemption, including the court's finding that the KCC overstepped its authority by imposing state requirements on a federal market participation. That is a field preemption finding. The court also found conflict preemption, that the regulatory burdens imposed by the tariffs here are contrary to policies in federal law that the Federal Energy Regulatory Commission sought to promote, namely a streamlined and quick process for registration, and FERC specifically rejected comments by the KCC in the federal rulemaking proceeding, in which the KCC asked for more state authority to essentially do what it did here. And FERC said no. And then the KCC and Evergy went ahead and did it at the state level anyways. And third, even if the KCC's tariffs here were not preempted by federal law, they still exceed the KCC's state statutory authority. For the KCC to approve any tariffs, it needs to meet at least two criteria. First, it has to be able to point to some statutory authority, giving it substantive authority to regulate the activities that are the subject of the tariffs. Second, it has to ensure that the tariffs do not conflict with or regulate within a field that's the sole domain of the federal government. The tariffs in this case fail on both counts. So they exceed the KCC's statutory authority. I'd note that in its order approving the tariffs, in response to petitioners, Sierra Club and Volt Solar's opposition to it, the commission identified three purported bases for why it can impose regulation on the act of registering in a federal wholesale market. It pointed to what it called its inherent authority, because this touches on electricity generally. Second, it points to the auxiliary clause in statute 66-101, giving it necessary and proper authority to regulate. And it pointed to the Supreme Court's decision in Dennis, if I'm pronouncing that correctly. On appeal, the commission does not appear and does not submit briefs. Evergy defends the statutory authority, but on three different bases, and explicitly disclaims relying on any of the bases the commission relied on. That alone waives any defense. You cannot defend an agency decision on reasons the agency did not rely on in its own decision. But beyond that, the reasons given by Evergy are incorrect. Evergy makes three arguments for why the KCC has authority to regulate this act, which again is an act of registering as a federal market participant with the federal market regulator in the SPP market. So first it says there's policy reasons. This is a new field. Demand response is new. Competitive markets are new. The commission should be given some leeway, essentially, that even though it lacks statutory authority, it should have the ability to regulate anyways. Second, it points to a new statute, 66-101G, which gives incidental powers within a narrow field to the commission. And third, it just straight out denies that the tariffs at issue here regulate customers at all. So as to the first, longstanding case law says that agencies have to be able to point to specific statutory authority. They cannot rely on inherent or presumed or even policy arguments.
Can they rely on a statutory grant that is exceedingly broad?
It has to be able to point to one first, and it hasn't here. So the commission pointed to 101, 66-101, which gives some necessary and appropriate regulatory authority, but the Supreme Court in the KEPCO decision, consistent with a number of other states and federal courts interpreting analogous statutory language, rejects the claim that that expands the scope of authority. Instead, the agency has to be able to point to a more specific statute granting that authority. So to the extent that Your Honor is referring to 101, that broad grant. That's already been, that argument's already been rejected in the Kepka decision. To the extent it relies on, or Evergy relies now on 101G, which has some slightly different language, that again, the text of that statute is cabined by the prefatory clause, which says, while you're regulating utilities. So while you're regulating utilities, you can have some other incidental power to do so. That does not authorize the KCC to do what it did here, which is to step outside of regulating a utility and instead regulate consumers when they are interacting with third-party federal market operators. Turning.
I mean, it seems to me, we have cases that talk about this whole bundle of the consumers. And I'm not good on the precise terminology, but that there is a cooperative state and federal regulation of this whole delivery system of electrical energy. And how is this outside that sort of broad cooperative system?
So that, I think that goes to the preemption issue in this case. And there are cases referring to some cooperative federalism. But what those cases hold and what other cases hold, including NARUC decision, including New York versus FERC, a number that we cite, all say that the states have to stay within their lane, even when they are cooperating within this regime. And so states have authority, and we do not dispute that the state has authority to regulate electricity supplied by Evergy to the customer and some of the customer's loads on the system that may affect reliability and safety. But that's not what the tariffs here do. They don't directly regulate loads placed on the system, any usage that may affect system reliability, system safety. Instead, what they say is, if you go and transact with a third party, we're going to set up a checkpoint in front of the federal government's checkpoint, and you have to meet our requirements before we'll let you through to the gate, to the federal market, where FERC is the gatekeeper. And so that's not cooperative federalism. That's a duplication of what's supposed to be a federal exclusive role, which is.
I mean, any request by Evergy for information from these consumers would be preempted in your view?
It is preempted to the extent that it attaches, which the tariffs here do, attach to the act of registering as a federal market participant. So if the tariffs had instead said, for example, if any customer is going to modify their load, their consumption by more than 50 megawatts within 5 minutes, you need to give us a heads up. All right, that applies to everyone. That doesn't attach to federal market participation, and it's not a precondition of federal market participation. I think that would be fine. That would not be preempted, and it was probably within the KCC's statutory authority under state law also. But again, that's not what the tariffs here do. The tariffs here don't say anything about load changes. Well, that might be the downstream intent for the commission to be able to affect those things, loads on the system that may affect reliability. The act that is being regulated is, if I'm a customer and I want to sell my demand response to the interstate market regulated by FERC, I have to get permission to go through that gate in the first place. Right? And that's the problem. Fundamentally, that's the preemption problem, is it sets the state up to regulate an activity that is exclusively federal.
What does it make a difference? And I don't know whether it's true or not true, but I mean, Evergy's counsel has said it's simply a ministerial function. You fill out forms and check the boxes and you're in. Does that change the analysis in any way?
It doesn't, for a couple of reasons. One, that's not correct. The tariffs in the forms that are in the record is not just check the box. Evergy can review, quote, the accuracy of data and information provided. They can request additional documents as may be required by Evergy, And then it has to be to Evergy's satisfaction that both the information is sufficient and it puts itself in charge of monitoring the customer's performance in the federal market in compliance with the federal requirements. And can then, after the fact, deny or I guess rescind any approvals. And so there's not only significant substance there, but it's also incorrect that this is the only source of this information. Right? So when a customer goes to register demand response in the wholesale market, they fill out application with SPP, and the KCC and Evergy get notice of that and get that information. And so really what Evergy is asking for here is a second layer 30 days before a customer applies to the federal market to get information. And FERC has already said how much information is needed and how much is too much. And this adds another layer that is too much under FERC's view and increases the timeline beyond the 45 days that FERC decided should be the maximum for notice before participating in the federal market.
So what recourse does the retail customer have if the Evergy says this is insufficient?
Unclear.
It's unclear.
Unclear. Unclear. There's no provision in the tariff. You know, I suppose a customer could file a complaint at the KCC and litigate that for, I don't know, a year is what it took this case to get from application to decision, which is, you know, just adds another year on top of the 45 days plus 30 days that the tariffs set up, which frustrates the federal policy of kind of a painless, quick process in order to maximize the amount of participation in the market.
It was my understanding that this new tariff or amended tariff was in fact originally filed in 2018. And that customer participation and Evergy's consent to that, whether or not they consent to it, was already included in that existing tariff from 2018. Is that correct?
Partially. So there was a tariff for one of the utilities. So there's actually two utilities here. One of the utilities had a vague provision that said you need permission to participate in the federal market. The other utility had none. Right. And so for Metro, the utility that covers this area of the state, there was no tariff until this decision in 2024. So as to the first, well, as to both, right? The premise for Evergy coming in and filing for this is that demand response was just starting to take off in its service territory as of early 2023. And that was the purported need to have this tariff in place. And so there may have, one of the utilities had an ambiguous tariff provision existing from 2018, but apparently no one was making use of it until right before this tariff filing, is my understanding. It's also the case that, it's also not the case that Voltus is the only demand response aggregator that customers can sign up for or with, nor is it true that they only provide service for industrial customers. I think the only record information we have is about Voltus is that at the time of their filing in 2023, they did serve industrial customers. I don't think there's a statement that they only serve industrial customers, even at that time, nor is there evidence that they don't provide service for residential customers. And in fact, they do. Look at the.
And I had a question about the standing. It's probably kind of prosaic, but my understanding is your members, but for these reporting requirements, filling out these forms and providing the information, they would participate.
That's correct.
But did any of them participate before this and then drop out?
No, because it was just starting to take, I mean, this is the irony here. The market was just starting to take off when Evergy came in and asked for these tariffs which then imposed the burdens. And they were so effective. I mean, I think it's evidence of the severity of the injury. They're so effective that it convinced people not to sign up in the first place. So that it kind of jumped in front of them and their intent to do it. You know, that their declarations say, you know, vote for this, I will. And the declaration from Volt Solar's manager notes that Volt Solar has customers in other states that are participating as residential customers in demand response in wholesale markets. And that they expect, because of their conversations, similar interest from the members in this state. In addition, as to standing, the declarations and the petition are not the only source of petitioners' standing evidence. In order to intervene in the KCC proceeding in the first place, Sierra Club and Volt Solar had to move the commission for permission to intervene. And as part of that, they have to show that their interests will be affected by the decision, and made that showing. It's in the record in volumes 3 and 4 of the record. And the commission agreed in granting their intervention, agreed that the petitioners, Sierra Club and Volt Solar's legal interests and participation in the markets would be affected by this decision. And so to the extent that there are findings by the commission as to their injury and their standing, it's actually in the order granting intervention before the commission and not in the final decision cites that Evergy's counsel. Again, to grant the tariff, the commission had to both point to a specific state statute giving authority to regulate customer participation in wholesale markets. There is none. It cannot point to that statute. The statute it pointed to, Evergy no longer uses to defend the decision. And even if it had the authority, the decision steps into a federal market, setting up essentially a toll gate in front of the doorway to the federal market and says, you have to meet our state level requirements to our satisfaction before we'll let you into the gate to the federal market. That is both a field that is the sole domain of the federal government, and the number of additional requirements imposed by the tariffs conflict with the federal policy of a streamlined single source of decision-making on who can enter the federal market, as well as the maximum timeline the federal government says it should take to register in their market. Unless the court has other questions.
I have a question that I posed to council earlier. Curb and other interveners originally objected to the tariff, and then there's negotiation, and Evergy changed some provisions in that tariff application, as I understand it. You know what those provisions were that ultimately, because they got dropped out, Curb and the other interveners agreed to this amended tariff?
I can't speak to Curb's thinking or the other interveners' thinking. I can tell the court what my understanding changed between the original application and the final tariffs.
That's what I'm interested in.
Yeah, so the original application, the forms essentially and the tariffs said to operate an ARC in Kansas, you need our permission. So the entities like Voltus would have to sign the forms and be subject to regulation under the tariffs. In the final version, they substituted the customers, so essentially my clients, as the regulated entity under the tariffs, and said that the customers have to get permission and they have to fill out the forms and they have to sign and submit the forms to us. That's essentially the only substantive change from the beginning to the end.
Thank you.
Thank you.
May it please the court, Judge Booser, I did want to address the question which Mr. Bender did address, which the change that basically brought some of the holdouts on board to the settlement was in fact having this information submitted by the customer as opposed to the ARC, and the concern that was brought up by having the ARC fill out the forms and submit the information was that this would be seen as regulation of an ARC directly and would raise some jurisdictional issues. And therefore, this brings us back home to the fact that this is in fact regulation of impacts and burdens on the retail grid and regulation of a relationship between a retail customer and the retail provider, which is what every tariff is. That is standard regulation. That is standard right down the middle type of regulation under 66101, which is the jurisdictional basis that Evergy has cited throughout this case. I don't know where appellees are getting the idea that we didn't cite a statutory basis. We did. 66101 provides the KCC's jurisdiction to regulate the retail market and retail providers like Evergy, which is what is being done here. I do want to address a few other issues. First off, to the extent there is an argument that the court found field preemption applied, that too would be an error. Field preemption is reserved for things like immigration law and areas where truly a field is preempted by clear congressional indication. That's not the case here. And in addition, the conflict preemption, this is in fact a clear exercise and I think a implementation and of cooperative federalism used properly in this context, where you have a state saying, we want to promote and allow DR aggregation to move forward. We have to make sure that we protect the reliability and safety of our distribution grid, however. And so we need this ability to understand what's going on through that process. That is clear cooperative federalism, where this regulation promotes, in fact, the DR aggregator position. So
similar utility plans in other jurisdictions?
I'm not really. I mean, I don't know that have we, I don't think there are any that are real specific on point. We may have cited to some states that have found similar dual federalism scopes within somewhat similar contexts in our brief, but I don't know that we have real closely similar regulation in other states.
Evergy didn't steal a lot of other places.
Not that I'm aware of, no. It's always easier if you're not kind of leading the way. I do also, Judge Malone, want to point out the retail forms that you held up. Those are retail forms. They're not necessarily residential forms. So those really are used for retail, commercial, and industrial customers. And I think the evidence in the record absolutely shows that Voltus did not and has not operated a residential DR aggregation in the wholesale market in Kansas. That's what the record shows. The record is clear, and we have to decide the case based upon the record. On the Nehru case that was mentioned, Your Honor, I want to read a quote from that. Under the Federal Power Act, state regulators retain their authority to impose safety and reliability requirements without interference from FERC, and DERs, so the distributed energy resources, must still obtain all requisite permits, agreements, and other documentation necessary to participate in the federal wholesale market, all of which may lawfully hinder FERC's goal of making the federal markets more friendly to local DERs. That's the Nehru case, 964 F 3rd, 1177 at 1181 from the DC Circuit. That's exactly what we're talking about in this case. This is a sphere reserved for the states, and that's quoted on page 39 of our brief. That's a sphere that is reserved for the states, and there's an understanding under this law that this type of documentation, permits, agreements necessary to participate in the market are permissible, all of which may lawfully hinder FERC's goal. So that is how cooperative federalism works. They bump up against each other, but I think the district court and what appellees are arguing here are let the federal government muscle the state out. Let the federal government just kick the state out of any regulation of this area. And that's not acceptable. That's not appropriate. That's why the district court's opinion needs to be reversed. If there are any other questions, I'd be happy to answer.
Apparently not, counsel. Thank you
Appreciate
very
it.
much for your excellent briefs and your arguments, and we'll take this case under advisement and get something to you as soon as we can.
Thank you, Your Honor.